Hello, everybody. It's the live stream again, and it's is it the 9th today? Monday, the 9th of December, 2024. And Mike, Shannon, and Karis are here. Although Karis, you're not quite in camera. Oh, there you are. Yep. Hello, everybody. And any news that you'd like to raise before I start rambling on?
No, I didn't. I forgot to mention actually. There's a little bit of ramping up with landlords getting their heads around the proposed bill. They're kind of talking about it coming in next Easter, in terms of the whatever it's called, the housing bill or whatever you call it. But yeah,
Oh, the one
they're gearing up for it.
ending Section 21. Now that's going to be interesting because there's a lot of grey areas I think they need to smooth out. I did see, because one of the interesting things for me recently was I had been wondering how they were going to enforce one of the new provisions, which is that you can only get, there was a ground for possession where you want to sell the property, and you can rely on that. But the question I'd wondered was, what happens if somebody, I mean, presumably all the landlord needs to do is go to court and say, yes, I want to sell the property, and put in a statement or something. And then after the tenant's been evicted, we find that they're reletting it for higher rent, or just reletting it generally, and they never resold it. And it's now going to be a criminal offence to do that, which is quite, I mean, they're taking it quite seriously. I thought they might fine people, or it'd be a civil action, but a criminal offence. I mean,
Who's going to enforce? Does say who's going to enforce it? Because yeah,
I think the local authorities.
Imagine ringing the police about that.
Yeah, exactly, exactly. But I think the local authority will enforce it. So what we may be looking at is, and another thing I've got to look into is. I haven't been for years. I've been meaning to do this. Is to take action to require local authorities to investigate hazards at the property, because it's common now for what used to be environmental health departments just to not be functioning really. So to go in there and say yes, we declaring this place unfit for human habitation is pretty unlikely. So yeah, I'll come back on that. But I think we'll have to have some dedicated sessions on the new laws when they come in. I'll just see if we've got any. We'll get the comments up and see if we've got anybody out there. Bear with me a sec. Comments. No. I should have got those up before we started. Probably nobody's commented anyway, but best to check. So I'm going to go in Ecamm.
There's a few people saying hi.
All right, great. You can see them. Thanks. Comments and reactions. Oh yeah, here we go. So hello to you, Cheeseface. We're all well. I'm well. I hope everybody else is. And Lynn, hello. Hello to you, Lynn. And I'll tell you, I was just saying to the others before we went live, that I've actually read, I think it was three recent ombudsman decisions this week, which you can get from the website. I might just jump through to the page so I can share my screen on that one. So that'll be guests on my screen. Oops. So that's the wrong screen, but I'll get to it. Hang on. Which one is it? Oh yeah, I see. I've done that. Okay, hang on. If I put this up here, hopefully it'll come. Oh, I know what I've done wrong. It's not that one. It's the. Oh no, there's that one. Bear with me, I'll just put this up on here. And then if this comes up here, and then I make that bigger. That didn't work. It all seems much more complicated when we're live. You can just see in the background there my the screen that I'm trying to show you. So I'm just going to close that one, and I'm going to add. If I can just change that to no. Oh dear. Well, maybe I'll just have to do this without a link or a page. Sorry. It should have been in that one. I'm just going to have one last try, and then we can focus on it. So if I go in there and then change that. Aha! Can you see it? Is that better? No? It's still pretty bad. Oh God, that's really bad still. Sorry. Maybe it's a different one. So let's just try tertiary. Is it that one? No, it's definitely not that one. Not that one. Not that one. And it isn't that one. Right. Well, I'll just tell you about it, and we'll go without that. So I don't know why that's there now. So I'll just go back to me and guests. Yes, without Mike in there again. There's a jinx on here. I can fix that, I think. Yes, right. Great. So what I read was three ombudsman reports, all about unsuitable accommodation, and all people got compensation for having not been moved on. And I'm just thinking it's almost universal now, this problem of people getting put in unsuitable accommodation and then nothing happening. But the thing that's so frustrating about the ombudsman is that the actual awards are pretty good, really, because you get. I'll just get that out of the way. You get, I mean, £3,000 for a delay in providing alternative accommodation. I mean, obviously, it's not as big as some of the awards you hear on the news and stuff for other things, but I mean, it's worth writing a letter of complaint and then following it through. But what I was wanting to ask you, Mike, because you've got, and Shannon, you've got more experience of doing these ombudsman complaints, is, I suppose, two questions. How easy is it, do you think, for your average member of the public to pursue a complaint through the complaints procedure and up to the ombudsman on their own?
Doable. I mean, just going back a step, one thing I say is that weirdly you get more compensation for being put in unsuitable TA than you do getting getting left sleeping rough. So if you're sleeping rough, you get between 150 and 350 pound a month, probably more like 350. But if you're in unsuitable TA, then you're getting between 100 and 200 per week. So it seems like a bit of I don't know why it's risen like that, but I think you're right in terms of unsuitable TA claims, or if that's the right word for it, compensation kind of complaints or whatever. It's relatively easy because it's easy to prove because you can just prove the dates that you were in that accommodation, you prove you got kids or whatever it would be. I would say that I think it's plausible that people can get all the way to the end, but what I'd say is councils more and more just ignore complaints. You've got to chase the first stage complaint. You've got to chase the second stage. You've got to complain at the first. You've got to complain that the first complaint's not complaint. It's not been responded to. You've got to complain that the subject access request hasn't been responded to. And the LGO, once you get to that stage, they're very good. But the council effectively, I think probably I would speculate that if they realise that they're gonna look bad, they know their only line of defence is just to delay and kind of just not respond. Um, I would speculate that if the complaint's not sound, that they'll respond actually quite quickly and say your complaint's not sound. There's nothing we're going to do. But I think where it's valid, they're probably best line of defence is just to ignore it and just hope that you go away. So I think yeah, I've only done it not being homeless, so even then it's going to be frustrating. It can take many months. But I think if you're in the middle of everything, it's probably less plausible because you've got to remember, you've got to keep track of like which date is the complaint due. You've got that complaint again. You've got to keep going back to them. So yeah, I think it's doable, but I think it's probably quite an effective tactic councils use in terms of just obscuring it by not responding, which is another thing to be annoyed at for, really, because it's completely unjust. But yeah, that is what it is. I think when you actually speak to an LGO officer, they're pretty nice, they're pretty helpful, and they're curious. They don't just take what the council says, or certainly less
Yeah.
than they used to anyway. So
What I was going to ask you as well is if a person how detailed and sort of legalistic does a complaint have to be for the ombudsman to sort of take the bait and then start investigating it themselves?
not very. I think that I think if you had no understanding of the law, but you could tell something had been done wrong, and you just complained about that, I think the LGO would take the gist of what you're saying, and that they then applied the law to the situation. Now, it still obviously really helps if you do understand the law a little bit, because then you know what you're actually complaining about. I think probably one of the biggest mistakes people kind of do is they'll focus too much on the fact that the staff member was rude, and I get why that is. It's a horrible experience to be in, but the fact is, it's harder to prove that the staff member was rude than it is that you've been in B&B for 20 weeks or something. So I think as much as people can, they just need to try and focus on the factual problems rather than the more subjective
Yeah.
stuff. Doesn't mean to say not to try it, but I think a good complaint is going to need to be. It's probably going to have a sense of like some kind of black and white error or failure that the council did, and then you can build other things around that. Is probably how I kind of suggest people do it. So you can complain about staff being rude. Don't get me wrong, but unless it's kind of tacked onto a staff member who's a housing officer who's already shown to be breaking the law in other ways, I think the LGO would be less inclined to side with the homeless person unless there was evidence somewhere else that the housing officer was already breaking the law somewhere else. So yeah, but yeah, I don't know. I think I'm interested to know what the background of the LGO investigating officers is, like whether they've been previous local authority workers or whether they're something previous advocates or something else. I don't know.
Yeah, I think in the future, I mean, last week we were talking about, or I was talking quite a lot about statements of case, and or was it the week before? It was a while ago. Do you remember I was saying how important they are for setting the facts out and untangling the threads? And I was thinking that once one of those has been prepared by a solicitor, at the end of, because, sorry, I should say the problem for solicitors with the ombudsman is that the legal aid doesn't cover it. So if a solicitor helps somebody make a complaint to the ombudsman, they basically got to do it for free or charge privately, which charging privately isn't really an option. Well, it is an option, but it's going to take up a lot of the compensation, and it sort of goes against the spirit of the thing. But I was thinking what you could do is have a standard guide to how to complain to the ombudsman, send somebody their complaint. So send somebody their statement of case and say, look, we just updated this to say what happened at the end of the case. You can probably get away with doing that on legal aid and say, now, if you follow these steps, you may be able to get somewhere yourself. And the other thing I was wondering is to what extent, even if people haven't been a client, if I did some guidance on how to prepare a statement of case or a basic chronology, people could then make the complaint. But it's quite difficult. I think, as you say, Mike, one of the most difficult things is to, if you're on the receiving end of maladministration and injustice, it's difficult to figure out which is the actual legal or maladministration issue, and not to get distracted by just people being unpleasant to you, which hurts more at the time somehow. That if you're in unsuitable accommodation and somebody's rude to you about it, you may think the rudeness and the lack of help is worse. But I'll come back on that. A couple of
But
comments here. Oh,
you
sorry,
can
go
go
on.
to the you can go to the LGO once you're suitably housed, couldn't you? And then that might make the process sort of easier. So is it 12 months after?
The
And
time
I
limit
think
for
it's
complaining. Yeah.
yeah, I think it's technically after you've been aware of the issue, but I think the LGO would be quite understanding, and they do sort of they are flexible around it, and they take it by case basis. So if you said actually the trauma and stress and chaoticness of being in unsuitable accommodation meant I couldn't complain till now, I don't see why they wouldn't take that forward. So you could
Yeah.
wait until you're due to be housed and then do it.
Also, that it's only when you're suitably housed, arguably, that the maladministration comes to an end, if you see what I mean. So maybe the 12 months doesn't really start to run till then. So yeah, I mean, I think it's such a shame that it's such a powerful thing that's out there, but it's sort of difficult to access. Um, and I mean, I can see why the government don't want to. If you've got a choice between funding hospitals and paying lawyers to make complaints to the ombudsman, it's not a big contest, but maybe they can get around that. So I've got a couple of comments here. We've got person X does on your screens, can you see the comment without the box without the larger box that gets in the way? So it says person X is
looks right from this end.
Oh, great. Okay, well, at least something's working. Person X is currently with the LGO. First LGO sided with the council. A new LGO was appointed and also took council's lies. Person X sent photos of current disrepair issues. It's now being reinvestigated. Which that does actually bring me on to a question that I had, and I don't know what you guys think, that one of the reasons that the LGO won't get involved in a complaint is if there was an alternative remedy which the person could have pursued, yeah, or a legal remedy. So with unsuitable accommodation, I mean, arguably there'd be the Section 202 review, which sometimes is mentioned that they could have gone for a review of the suitability, or even a section or judicial review proceedings. But I guess judicial review is a bit vaguer, so they might say, well, we're not going to expect everybody to be judicially reviewing. But the other one is with disrepair, because presumably they'd say, well, you can go to the county court and get an order requiring them to do the work. Have you come across that one, Mike, of them?
Yeah, I
Shannon?
think so I don't know what the actual rule is, because you're right. They basically would say that if there's another way, if they should have been taken through the court process or the review process, then it should have been dealt with that way. But with suitability of accommodation, they seem to be very focused on that. In the same way the housing ombudsman is focused on damp and mold at the moment, they seem to have they've seemed to pick that as being an issue they want to really kind of pursue, which I think is partly why we're seeing so many decisions come through with it, which is kind of a positive outcome. So yeah, I think there seems to be inconsistencies that crop up sometimes, but they seem to be ones where it kind of favours the homeless person, because effectively the LGO is getting involved in something which, on paper, they maybe shouldn't be kind of going that far. I don't know. So, I'll dig out in a minute. The LGO did a report about suitability of accommodation. I'm sure they did. I'm going to find it in a minute, because it just goes to Cheeseface's other question, which is, who funds it? I don't actually know the answer to it, but they do have some level of independence, because it does seem that certainly in their reports they are being openly critical of local authorities, which says to me that it's not a complete whitewash. Now, I'm not saying that it's completely independent either, and as I say, if it's staffed by ex-council officers, then they probably naturally have a sympathy to councils rather than homeless people. But yeah, so I'm going to have a little look if I can find that report that they did, maybe, I think it was like 18 months ago, something about suitability of TA. So I'll see if I can find it, and then might have more to say about it.
Well, in that report, I'm pretty sure it says that they were not cool, but they were okay that they understood that a judicial review isn't always possible, because of the nature of the sort of difficulty of it. So I wonder if that's why we're seeing more of these cases. And then there was something else I was going to say, and it's completely gone.
Well, if
I
it
just
can't,
that was it.
oh,
If
come
it's
back.
disrepair, I wonder if they could go to the housing ombudsman as well as the LGO. So if in case, so then it might not be like the council's made a bad decision or anything, but if it's disrepair and it's landlords or the council's a landlord or whatever it might be, then the housing ombudsman might be the more appropriate ombudsman, which is potentially why the LGO is going, there's not much we can do.
I have to see.
Just put that the report about we're talking about, it was 18 months ago about suit. I'm just going to have a look. Yeah, it's in the live chat basically. If you want to have a link to it.
Oh, sorry, I'll go to that. Oh, people can see that, so I don't need to highlight it. The other thing I was going to say was, before I get on to Lynn's raised a question, which I'll come on to. One of the other problems with suitability of or unsuitable accommodation is this, that the legal mechanism for challenging unsuitable accommodation, if the council have accepted a duty to house you, is a Section 202 review. Now, the Section 202 review allows the council 8 weeks to complete the review, and then if the council uphold the decision that the accommodation is suitable for you, you have to appeal to the county court, which could take probably about 6 months. So that's 8 months you've got. So if you're in unsuitable accommodation, it's going to take you 8 months to get it challenged. And even then, actually, even at the end of the 8 months, the county court doesn't say, yes, rehouse these people now. It just says, go away and think about it again. So they can come back and do another decision to exactly the same, but just make it lawyer proof. So the problem is it doesn't allow for any remedy, really, because when Parliament passed the Housing Act 1996, they were under a lot of pressure from the administrative court to get homelessness cases out, because a huge amount of the High Court's time was being taken up deciding whether somebody's accommodation was unsuitable or whether they were intentionally homeless. Because remember, in those days, there were no appeals. So they said, okay, we'll do this and we'll make sure that we deal with them really fast. And some of the first decisions on temporary accommodation said, you shouldn't need to ask for temporary accommodation pending the outcome of an appeal, because the appeal will be dealt with so fast that it won't be necessary, like you think within days or something. But that's broken down completely. So we've now got to the stage where I'm about to issue a judicial review against a council where they've refused to provide temporary accommodation pending the outcome of a 204 appeal. So we have actually issued a Section 204A appeal against the refusal to provide that temporary accommodation. But so far, the court hasn't even responded, let alone issued it. So we've given them a week and said, look, this guy's sleeping in his car. We're going to go to the administrative court on the basis that the county courts are so understaffed and underfunded that they can't provide a service anymore. And therefore, the only remedy for this guy is judicial review. So that would be interesting, because if the administrative court runs with that, it will amount to a sort of admission that the county courts have reached a point where they're not fit for purpose. So more to follow on that. I hope that makes sense. That was a bit of a legalistic ramble. And so we've got a question from Lynn here. So somebody else want to have a shot at answering this? When does legal aid eligibility start for a homeless person?
I can try and give a wrong answer. You can tell me why I'm wrong. So, right. So I guess I think when we use the term legal aid, there's actually technically two different things. So again, William Karras can correct me, but so you've got legal help and then you've got legal aid, but they're basically, from the outside, they look pretty much the same thing. And so the initial kind of, if you have a homeless problem, let's say you are homeless and the council say no for whatever reason, then you meet up with Karras, we'll do the paperwork, provide the a little bit of documentation, things like bank statements and not a lot else really, ID, kind of, I guess, probably at some point, a few other little documents. And then once those forms are done, which can be done in a few hours, effectively, yeah, they're on the clock, so they can then do work, and they can kind of contact the council. They can kind of carry out investigations and so on. I think from it seems it's a very quick process potentially if you've got all the documents available and so on. But that's my answer. So again, yeah, feel free to obviously add to that. Go on, Shannon.
Well, it's more a question because I know what you're saying, and obviously, Will and Karis, you have legal aid clients when there's an issue, right? But say the system was working, which will take a minute to like try and imagine that, but all the systems are working. Could someone get legal aid from the very beginning to make a homeless application because it's a legal process and get the help right from the beginning, or would they need to have something go wrong with their case? Or is that just the way it is currently because the system's so broken, we only look for legal aid when there's a problem? Does that make sense?
It makes perfect sense, yeah. If I have a stab at that one, the answer is if somebody just said, can you help me, I fancy applying to the council for assistance, can you help me fill in the forms or do whatever, the legal aid agency, if they were sort of somebody was involved in the conversation, or they were later assessing my claim for payment, they would say, no, that's out of scope because you didn't actually have a legal issue. You just, and the legal aid isn't there to help people make applications. But the good news is that it's so common for people to get messed around that literally all they have to do is go away and try and make an application, and then they get told something like, what's a homeless application, or go to another council or any council other than us, the usual sorts of things. We don't know. It's quite a common one. It's so ridiculous, but we don't do housing anymore. That's so as soon as you've got told something like that, then you're within scope. So I would say legal aid, the answer to Lynn's question is that there's two halves to eligibility. As long as you're financially eligible and you're on benefits or you've got a low income, you're okay for that. So as long as you're homeless or threatened with homelessness and you have a problem, that somehow that you haven't got, the system isn't working, then you'll be eligible. You could probably get away with, I mean, as long as it wasn't obvious that the person just hadn't even made an application. I think you'd have to say, go away and just try and contact the council and come back and say if it's gone wrong, then we could get involved. So I hope that answers the question. And that it is pretty generous. I mean, I've never had a case, I've never had the legal aid agency say that person wasn't entitled to legal aid for a homeless case. And they are pretty good on scope. I mean, it's quite, I mean, well, for my cases, I don't know if other people are having problems, but like with a possession case, you can get free advice and assistance as long as if you're at risk of homelessness. So that raises, your risk of possession proceedings. So you could say, because on the other hand, welfare benefits is outside scope. So if you get a letter from Housing Benefit or message from Universal Credit saying we're not paying your housing costs, arguably that's outside scope. But as soon as the council come back to you and say, you've got rent arrears, we're thinking of evicting you, you're in scope. But that doesn't mean you can start sorting out the welfare benefits, but it does mean you could say to the council, we're making a homelessness application because we're worried this person needs help under prevention duty for you guys to sort out the benefits problem, and leave it to the council to do it. So I hope that makes sense. It's a slightly longer answer. And I was going to raise, since there's no other comments and questions right now, I don't think, I'm just going to say a little rant I wanted to have about people who are being, I don't know if other people have had this problem or come across it. is people are being placed in hotel accommodation. That's like travel lodges and what have you. And this is particularly a problem for single men rather than people with children, although it does happen to everybody. But the problem is of communication between the council and the hotel often means that people get told at very short notice, oh, your booking's ending tomorrow or Thursday. And that's the first the person knows about it. And and it's very difficult to get hold of anybody at the council these days. I mean, you ring up and you're on hold for ages. Um, you might get a reply to an email, but meanwhile, you'd think that the way to solve that is for the person on reception at the hotel to just contact the council back and say, could you tell us why you're cancelling it? And Mr. So and so would like to have a word with you. Is that all right? And hand the phone over to them. But it's just a complete, they'll just be told, no, we can't do anything. We can't even tell you who it was that told us that your booking was ending, because that would be, I've had that recently, that would be a breach of the Data Protection Act. And so people are often left week after, the booking only usually lasts 2 weeks. And it's particularly bad when people are being housed by social services, because social workers are not housing officers, so they're even worse at maintaining the bookings. So every week, I was having one poor woman, every week she got told your booking's ending, and then she'd have the nightmare of trying to get hold of the social worker. And I was actually having to write letters threatening legal action if they didn't just call the hotel up. So I mean, I don't. The problem is hotels are completely legally unaccountable. Really, you can't really do anything because the hotels got a booking with the council. It's between them and the council. They don't have any public duties. So it's a bit of a sort of modern nightmare, that one. So
My guess is
yeah,
you've got like a bit of an interesting bit of politics as well. So the hotel bosses love councils because they pay lots of money to them, but the frontline staff have to deal with lots of people coming and going and not knowing what's going on. So the frontline staff probably have very little sympathy for people who are actually homeless, and probably are like, oh, why do we have to take these people in at all?
exactly.
And that kind of adds to the fact that they're just not in any way helpful. And but it's not just them. I mean, they're in Bedford. It's less so initiatives been identified and kind of improved on a bit, but it was a standard practice to basically, your booking would end at sort of 10 in the morning, then you'd wait till 5 o'clock at night to find out if you were going to be in the same B&B that night or somewhere else. And so, and yeah, the council like, well, we're overrunning, we haven't got enough resources. But again, it's something they improved on, so clearly they could do it if they wanted to. And I think again, it's that idea that the housing officers were not able to kind of conceive that people would be anxious, because of that system. They were like, oh, we're going to ring them. So what's the problem? But the point is that when you're in that situation, you've got no reason to think have any confidence in the council that they're actually going to act in your interests. So it's very, very difficult indeed a lot of the time.
Very trauma informed, is it?
No. So I think we got a question from Cheeseface. So the question is, how does the difficulty contacting councils affect solicitors? E.g., when you write things like "you have 7 days to reply," you circumnavigate this by contacting the higher ups. Oh, do you circumnavigate this by contacting the higher ups? And the answer to that is it does affect solicitors. But one advantage we have over most, I mean, if I write to the council and say, please could you reconsider your decision, or please could you carry out a review and move this person or something, or I may not get a reply at all. So I have to have a system where I write a letter. If it's not something I can threaten them with legal action over, which not everything is, I would then write to them once and then send a reminder after 7 days. And then after 14 days, they get a message saying, I'm going to make a complaint in 7 days. And then I make the complaint. And usually, I mean, that's by then, that's sort of 28 days. So that's not particularly good. But if it's urgent and I need something with it, like if I say you have 7 days to reply, I wouldn't quite use that wording. I would use if I haven't heard from you by 7 days' time, I'm going to issue judicial review proceedings and ask a judge to order you to do what it is I'm asking you to do. And I'll also be claiming legal costs. And then the magic bit about that is I send a copy of that to the legal department as well. And the legal department tend to sort of freak out because then they're worried that they'll be open to criticism because they ignored correspondence, which led to legal action being taken against the council and costs being awarded, and that they'll get blamed. So they then can sort of rattle the cages at the council and get people to do things, which is good. And there's another message from this one here.
It's
from
a two-parter.
I beg your pardon?
There's two parts to it. There's another bit.
Yes. So that one says there's problems finding. Sorry, William Flat Law Channel. There's problems finding one available that'll take legal aid or a no-win, no fee. They all ask who they rent from, and as soon as they say who is when they have no capacity. And then the second part of that question is, isn't that odd? Are people obliged to say who they rent from at the start? How can that be overcome? Oblique worded, please. Did we? I mean, no disrespect. If I think we talked about this a few weeks ago, either on this show or on your one, Mike. But can I have a go at just quickly answering that?
Yeah, I mean, can I just
Yeah,
get to
fire away.
understand the question a little bit better? So, when I guess what they're talking about here is, is it a private landlord, is it a social landlord, or is it a council landlord? Is probably the difference. So I think, yeah, and I'm interested to know what the difference is from a solicitor's point of view. Like, what difference that makes to a case, whether it's easier or harder to go after a council landlord or or whatever.
Well, yeah. Could I just ask Tiff if you? I think I know what the answer is, but which sort of landlord is more likely to get the phone going dead on you, sort of thing, and being told there's no capacity? Is it that if you say you've got a private landlord, are they not interested? Or if you say you've got a council landlord, are they not interested? I'm suspecting that's the other way around, that they don't really want to take action against private landlords. But Cheeseface has asked the question. We found the same, but Will said solicitors love councils as they get paid. Yeah, that was the last time we talked about it. So the answer is, in my experience, although they will deny it, nearly all legal aid solicitors engage in what's called cherry picking. So there's certain cases which are cherries for solicitors and certain that aren't. So the ideal case for a solicitor on legal aid is a case where they're going to get legal costs awarded against the landlord, and also that those costs will be paid. That's a couple of reasons. One is, hang on, yes, and Tiff's answered the question. It is that when, hang on, it's when a council landlord is said. Okay, so I'll come back to that because my experience is the other way around. But
no, I think that's the way maybe where you phrase the question.
Sorry,
so
I mean,
it's possible that they're saying
yeah.
that that's the more likely one. I don't know.
So yes, well, let's assume. Sorry, maybe I'm misreading that comment, but so solicitors would want a case where they're up against a really aggressive local authority that isn't going to settle, and is going to run the case all the way to trial, and then they're going to get thousands of pounds costs against them. And one of the good things about local authorities is, well, it's sad really, that they are good at paying legal costs. I mean, they've got better things to do, but you can always rely on them. That it's a bit like the government. They've got no money for many things, but if they want to send some missiles to Ukraine, they've come up with the money for that. And local authorities seem to come up with the money for paying legal fees. So to go back to where I was, if you say I've got a private landlord, many solicitors have had bad experiences because the private landlord may just be a sort of single individual who doesn't really know what they're doing. I've got one private landlord I'm up against who is definitely not well mentally and is sending me nonsense letters and things, which even the worst councils don't tend to do that. Or you can get make a complaint and you'll get somebody different. But so that's why it is. So if you say, I've got a private landlord, they'll probably not want to go against them or take on the case because A, it's a hassle because the landlord may not understand the law, and B, at the end of it all, the landlord may be broke and they will never get any money out of them. I'm guessing that. When the council is a landlord, though, the opposite's true. It's unfortunate. I mean, I try to. I mean, if it's disrepair, I mean, can I put my hand on my heart and say I don't cherry pick? No, I would. I mean, I wouldn't cherry pick based on who the landlord is. I would feel a sense of, you know, I'd feel more positive about taking action against the council. Well, partly because I don't particularly like taking action against individuals, because it's an absolute nightmare for a private landlord to get done by legal aid solicitors, because you've got limited money and your opponent's got a sort of the government funding them. And that's not to say I'm overly sympathetic to private landlords, but it's still, you have to have a bit of a conscience in what you're doing.
But
So,
sorry, Will.
yeah.
Should I just say, you'd look at the case as a whole and not just go, oh, their landlord's that person. You would look at the case as a whole and what the case is. So
Yeah.
it's not just about who the landlord is. They would look at what's going on, say cherry picking it, and they would look at how much capacity is and how long the case is going to take, possibly. So it is a bit of looking at it from that quick cherry pick, looking, oh, what have you got in your, what are you working on, and what have you got time to take on as well, wouldn't you? Not just, oh, the landlord's this person.
Maybe I'm being cynical, but I'm thinking a lot of people are motivated by their cost targets. Because the other about 3 weeks ago, there's emails that go around from different organisations saying, can any solicitors take on this case? And it was a case which was a Section 204. It reached the Section 204 stage basically, and they're saying it's ready to be issued. Anyone want it? And it was gone within 10 seconds. Whereas if you'd said it's a challenge against a Section 202 review, people wouldn't be so interested because they'd only get paid at legal help rates rather than the prospect of getting paid at commercial rates, which is what you get if you win. So I hope that makes sense. There are other criteria that people use for that solicitors wouldn't want to take a case on, and I could go into those another day. But I think if people contact solicitors' offices, and I know that I sympathise with people who do it, but if they're sort of ranting and raving and talking about wanting hundreds of thousands of pounds damages, I mean, a lot of solicitors think I just can't, I can't handle this. It's probably going to be more trouble than it's worth taking on this client, I'm afraid. But that's something that I think a lot of solicitors have got to deal with. We were just discussing it today. That I think this is, I'll be straight about it, but if you get approached by somebody who's clearly mentally ill and is behaving in an antisocial manner because of that, a lot of people will say, look, I haven't got time to deal with this, because it's much more complicated taking on the case. And if you've got somebody that's going to be shouting abuse at you on the phone and ringing your mobile at 2 a.m. Now that's not to say that I sympathise with people, and I have a few clients that occasionally, when they're not taking their medication, they ring me up, tell me how evil I am and stuff, and I can take that. But that's something the profession's got to address in the future, how we get round that. Sorry, Shannon.
Yeah, no. So I was just in that sort of situation. Would it be off-putting, or would it encourage a lawyer to take on the case if, say, a caseworker or like support worker or whoever it is, therapist, was to do it on their behalf or like with them and made that so the communication was through them? Or would it put you off because you're like, this person is complex because they've got a support worker? Or would it be like, oh no, brilliant, that's helpful?
Well, it depends how good the support worker is, and I hate to say this, but a lot of support workers make things worse than if they weren't there at all, because what they it's partly because support workers aren't trained, and I could go on and on about this, but they'll often make the client, they'll give them a false impression that they're very important and they don't have to do anything themselves. And then the support worker doesn't really know what to do, and then sort of backs out. And this is particularly, I've had some terrible experiences with mental health support workers. The people in hospitals, believe it or not, I had somebody's care coordinator. I wrote to them and said, could you tell me what you're doing in terms of what care is being done? I was told if I wanted to reply, I had to make a subject access request. Then I wrote to an advocate, because people have mental health advocates. And I said, could you tell me what you're doing in terms of asking for, because there was a question of whether somebody would be discharged from hospital into unsuitable accommodation or not. And I said, could you tell me what you're doing about liaising with the council or liaising with the hospital authorities to see if, because you want to avoid quite a common situation where they need the bed and they just kick the person out. And I was told that they couldn't make decisions about the person's discharge from hospital, so don't ask them. And I wrote back and said, I'm not actually asking you to make a decision. I'm just asking you who you're talking to about the decision. But you know, as you may guess, if I needed to have that, I didn't get anything helpful back. And then the problem is as well, you get a lot of community mental health teams that work closely with council. And so you get that problem you get with some advice agencies where their manager says, what are you doing writing to a solicitor? You know, the council we work with them. And so the line just goes dead after a bit. So no, I mean, ideally, a support worker, and you could have these what do they call social? I keep forgetting these people that work in GP surgeries now.
Prescribers.
Yeah, social prescribers. Those are exactly the people and support workers who should be getting in touch with solicitors and helping the person maybe control their anger, you know, or not sort of express themselves. But one of the other ironies is that if a person is involved in legal proceedings and their landlord has actually issued proceedings against them, then the fact that they're mentally ill and they lack capacity will count in their favour, and the proceedings will get frozen. And then there's a public body, the official solicitor's office, that will represent them and give. When I say represent, I mean they'll give instructions to a solicitor on their behalf. But before proceedings are issued, there's nobody out there that can do that. So it's a real problem.
It's also reliant on the fact you're giving someone else information to give to someone else. So that's Chinese whispers.
Yeah.
And if they're getting the information correct, like we've got to interpret the law in complex information to say it to someone to understand. We've got to make sure that they understand. So when you give it to someone else, there's that worry if it goes down the line and they've got to interpret this to make sure they understand. So it's kind of like that third person scenario. And sometimes they'll have ulterior motives, or they'll just be like, well, this is glorious. You'll be like,
and
hey,
sometimes
this is a serious matter.
support workers often, maybe it's a training or the approach, I mean, and maybe it's perfectly valid, but they see the giving of support as a sort of act of befriending and sort of trying to counsel the person rather than supporting them in taking action, which they may not feel so good about. So it's a tricky one, that, and I'd be interested to hear from support workers out there who have opinions on that. I'll just give a couple more comments. We've got Shiso says you.
And also support workers aren't regulated. Sorry. And also support workers aren't regulated either. So they are often of their own fruition.
No, it's true. So he says, yes, you have to keep trying. Try a free legal drop-in centre for advice and ask them to summarise your issues. They will do this in a format office people like to read. Yeah, that's quite right. But the trouble is that these free advice, I mean, if you can find a free drop-in centre, that's great. But they've been sort of closing down quite a lot, and it can take a while to get through to them. But I think I might try and put some material out there about how to summarise your case in a way that might get people to take it on. So
I think that's a really good idea.
Yeah.
Just on the basis of this kind of line of questioning from Tiff, what's Virgo solicitors' capacity like at the moment?
Well, sorry, you. I'm answering all the questions. Karis, what do you think?
Yeah, we have capacity, but it is filling up fast. That's all I'd say.
So if someone wants to go on wflatlaw.com or whatever it is, and just have a look at that list of solicitors, you get Virgos, and it might be worth giving them a call.
Yeah, I mean, we've been doing quite a lot of work on this, so I just say a bit that at Virgo Solicitors, which is a firm of solicitors in North London, but can take on cases from anywhere in the country. I've been working with them, and because I work as a freelance consultant solicitor, not an employee there, and so we're trying to build up a team that can deal with a lot of homelessness cases or housing cases, because there is such a huge demand. But we're still sort of building it at the moment and taking people on. Hopefully, once it's up and running, we can take on lots of cases. But at the moment, we're sort of at the early stages. But if you do get in touch, if anyone just Googles Virgo Solicitors, and you'll see a link to their page. I was going to do a blog post and say something about this, but unfortunately, dealing with urgent cases got in the way. So I'll just make. Then there's a good question from Cheese Faces. Sorry, we're replying to Tiff there. So Tiff said there aren't many legal drop-in centres. Yeah, that's I agree with that. Joe Advocate Services serve the area neither. The council closed us and stopped funding most. Yeah, well, that's what I've tended to find. And then Cheeseface has mentioned about does your GP surgery have a social prescriber? I mean, I'd be interested to know. I mean, hopefully more and more are, but even then, I'm not sure that they see their role as being sort of. I think a lot of people see getting involved with lawyers and stuff as stirring up trouble. Maybe some. It's not quite as easy as that, but maybe. Ideally, there'd be some sort of alliance of support workers out there that, or at least some sort of collective organisation that looked at ways and what is actually meant by providing support. But I'll probably get called speaking out of turn if I start telling people what support is.
No, I think it's good to say it, because I think a lot of support workers, a lot of people who get paid to support people, will do anything except the one thing which will get the person housed. So they'll just do, they'll kind of happily make cups of tea and whatever else. And actually, what the person needs is just a little bit of information about the way the system works and the bureaucracy, and a lot of professionals it's just not on their radar. They just they think that's a completely different concept of what they're supposed to be there for, and it means a lot of people just don't get the help they should be getting when actually it'd be quite easy.
And on the face of it, it's something that looks like it's also homeless people's fault. Because like I was in a webinar today, and someone with lived experience was like, what would have changed your outcome or whatever, and the person, if someone had just listened to me, and like, so on the face of it, all of those professionals in that webinar is like, oh, we need to listen more, we just need to listen and be nice. And I'm like, no, because they don't realize, they're not even considering the possibility that that worker could have actually done something and actioned something and helped them. So again, it's like, it's the system, because we're trained to have workers that don't actually help, that the most we could possibly ask for is that they listen to us. But that's not actually what people are after, even though it's what they say, if that makes sense. I'm not trying to dismiss what they're saying either, but
that's because the word. So when we say, oh yeah, I want someone to listen to me, some people would interpret that to be like, okay, you just want to sit down with a cup of tea and let me talk to you. But other people might say, well, actually, no, I want you to hear what I'm really saying. What I'm really saying is the system's shit. It's really unfair. It's completely like broken, and I need to know what, and I want to know how to get through it. And that's actually what they're saying. That's their message. And I think that's two different types of listening. But I think, yeah, I don't know. I think it gets lost in that kind of
no, it does.
sort of like really, really sort of what's it called, toxic positivity. That's sort of like kind of just approach you get from a lot of workers.
Yeah, why is it a revelation that, oh, we should listen to people and be nice? That's a revelation for them.
It is, but like, and also I think when I rough slept, like genuinely, when I was rough sleeping, one of the most positive or like whatever interactions was some guy who came over and listened with a cup of tea and bought sugar. That was the real like clincher, was he bought sugar, and I was like, yes, sugary tea. But like that doesn't say I needed to be listened to. It says so much more about how I wasn't listened to by the local authority or the job centre or all like the hospital, the GP surgery, every other professional I'd interacted with. Like that such small kindness means so much, all because of the failings of others. If that, yeah.
Although it is as it is a problem, as Mike says, that a lot of people think listening is then you listen and then say, do you feel better now? You got that off your chest, you know. I'm going home now. But the other problem that exemplifies it, I think, as well, is that legal help or the advice and assistance part of legal aid is called advice and assistance, and I always find that, I don't know, I've found that legal advice, people don't come to us for legal advice. They come to us for assistance. So if somebody comes to me and I say, yeah, actually legally you are completely screwed, you know, you're in a really bad place, and there you go, there's your advice. I tend to find that's just winding people up. Whereas if you say, look, I'm going to do this, that's what people want. It's like, I always give that analogy of going to the dentist and getting a lecture about why you've got toothache when you're just saying, please make it go away. I think I've kept everyone's quiet. Tiff's asked, social prescribers are separate. I think they might be funded by, oh, somebody, sorry, I'm getting quite a lot of comments now. Sorry, Tiff asks, are part of social prescribers part of social services? I don't think they are. I think they're part of the NHS. In fact, you've already answered that one. But there is a problem with another problem with funding of different organisations and support is if somebody is getting support services, they often don't know whether the person they're dealing with is NHS or council or which department they're from, which is confusing because you don't know where their loyalties lie or who it is that who's responsible for them. So here's something nice to say, you are all lovely people, but what's that lady's name, please? She's right. Well, I suppose is that either Shannon or Karis. Is that who you're referring to? Unless I'm missing something.
That's what I mean, because we don't get our names on our screen anymore.
Oh, now. I'm sorry. Sorry, Shannon. you're I'm going next. Okay, what I'm going to do next week is I'll put the names on. So yeah, I'm Will. This is Mike. Shannon over in the middle, just towards the edge, and then over here on the right is to the right of the picture, not the right. Generally, it's Karis. And I think that's probably it for tonight. We've done an hour, and I hope that was useful. I'm sorry about the technical problems. Oh, hang on, we got a last. Yeah, sorry, I meant to come back. Sorry, just give me 1 sec. There was a really good comment I had up on the screen about somebody not being rude, but just being anxious. Did you see that one? And then it was up there for a bit, and then. But I agree. But the problem with anxiety, and if you're anxious, you can come across, and that's not to say that I'm criticizing people for being anxious or saying that they are being rude. But if you pick up the phone and there's a very anxious person shouting, well, you're less likely to be sympathetic. It's something we have to deal with, and it's a training issue. Because I was thinking this the other day about why one of the questions I always get asked about housing, or frequently asked about homeless persons officers, about why are they so horrible to me? What did I do? And I have to answer, well, it wasn't you. It was somewhere along the line somebody made them look stupid or somebody threatened them, and now everybody's getting treated badly. And then I thought, I don't know if it's still true, but traditionally you think if you go to hospital and you see a doctor or a nurse, they are actually nice to you, especially if you've sort of been in your A&E or something. Nobody says, "What the hell are you doing here?" Or, you know, we're not open today or something. Then I thought, well, actually, it takes months, if not years, of training to get to that stage, where you can actually retain your sympathy in the crisis. Whereas I think the big problem for so many of the people we're dealing with is that the staff they're dealing with are just not trained, and that includes solicitors. We don't get any training to deal with mental health. Well, we didn't when I qualified. We didn't get any training to deal with this, and yet it's such a complicated issue. And like for years, I was asking people really insensitive questions of people who've been through traumatic experiences, and it didn't even occur to me that I was re-traumatized. You know, I might be doing damage by saying, "Tell me the most terrible thing your partner did in terms of domestic violence," so I can make a simple statement. So yeah, it's there's a lot. I think training is a big answer there, and so I hope I didn't mean that I was confusing anxiety with rudeness. Was I can sympathise with people can be rude if they're stressed out. I don't mind that, but it's just it will put some people off taking on the case, and so I think that's it. Sorry, there's a discussion. People are. What if it? Oh, no, sorry. Do people want to just spend a minute on this, or you've answered it, Mike? But
I've answered the chat, but there might be some more we can say about it. I mean, with all of a sudden, the chat was essentially, it's not something you can just keep extending for 8 weeks. The code of guidance is clear. It should be basically done on day 57. The decision should be made, or in an exceptionally complex case, you get another 3 weeks. But in the comments, I said complaining might be an option. You've always got to weigh that up with not pissing someone off, not pissing a housing officer off who then takes it out on you, which is very difficult to know. But I think if you can approach it gently and basically, kind of maybe go back to them and say, thanks for your email that say you're going to extend it by 8 weeks. Then you might say, well, I've been told that that's not actually possible, or something like that. Could you just confirm whether that's kind of the way it works? So I think that might be a gentler way to start off with. But ultimately, the ending of the relief period is actually really important for getting rehoused. It might seem like a bit of an admin thing, but actually, until you're out of relief duty, the time doesn't really start ticking on. If you're going to get social housing, that's when the time really starts ticking. And so, if you could have kept in limbo in this relief period, it's really not good. Well, it might not seem like it's important, but actually it can be. So I think probably trying to try and resolve that as best you can, as gently as you can get away with, is probably a good way of doing it.
yes. So we could talk about relief duty and stuff, and it's a big subject and what to do, because it is quite common that people the 8 weeks goes by and people just forget about it. But I suppose as long as you're if you're in suitable temporary accommodation, it's not as bad as it could be, but it is a nuisance. And I think Mike's right. A complaint should be made. A polite request for a decision should be made, followed by a complaint, pretty quick.
What I might just add to that very quickly. Well, sorry, guys.
Right.
Is that it also depends on the strength of your argument. So let's say, for example, you're definitely in priority need. So let's say you're pregnant, you've got dependent children, then there's actually less that the housing officer can do to retaliate, because they can't not say you're in priority need. But if you're arguing you're in priority need through vulnerability, let's say, then it becomes maybe a little bit more it becomes a bit more important to deal with it really carefully. And I think our answer to everything is try and get a solicitor involved anyway. But I think that can be a factor as well. So I think if you've got any kind of like doubt about what the decision is actually going to be, go in gentle. Whereas if it's blindingly obvious, your house just burnt down, or your house just got wiped out by the storm or something, then there is no kind of room for leeway for the council. They're going to have to accept the main duty. So just push it. I'd say push it quite hard at that point, probably.
Just to come back, Lynn's points out that the person that she's referring to isn't in temporary accommodation, so the denial of a decision is instrumental in denying them any accommodation. So what you should do there is challenge the failure to provide temporary accommodation, because regardless of whether the relief duty's expired or whether the full duty's been accepted yet, they're still under a duty to provide accommodation under section 188 if there's reason to believe the person is eligible, homeless and vulnerable. And if, as you say there, it's a vulnerability situation, then it's worth threatening them with legal action if they don't provide temporary accommodation. Would you agree, Mike, and everyone, if I'm missing something?
I think definitely. So, because if you're not in priority need, then actually it doesn't really matter whether the relief duty rolls over or not, to be honest. You know, technically, if you're definitely not in priority need, then maybe it's better if the relief duty does keep rolling on, because technically the council might help you out. But if you think you're vulnerable and you're therefore in priority needs, then yeah, you know, I would say get a solicitor. It's a difficult argument to make. As we've said, you know, maybe give Virgos a ring, but it's a difficult argument to make if you've never kind of come across the law before. And what we're dealing with here is a situation. If you're not in temporary accommodation now, then the council's saying, well, there's no reason to think you might be in priority need. So technically speaking, they should not be making any inquiries into vulnerability right now, because in effect they are satisfied you're not in priority need, and you could actually get compensation for that element. That would be, going back to our first question about LGO and stuff. That would be an argument you put to the LGO and say, look, you know, the council said it wasn't in priority need, and yet they continued to make inquiries into my priority need whilst I was not accommodated. That's the wrong. Yeah, that's maladministration there. But I think again, pragmatically, get a solicitor and get them to kind of talk through the details of the kind of vulnerability issue, and kind of work out whether they think the person would be in priority need or not. Is probably a good way of doing it, because if it's if you just got something really kind of quite trivial like a bit of tennis elbow or something, then solicitor would probably say there's no point fighting it. Whereas if there's actually more kind of substantive stuff, then it's very worth fighting for.
So in this case, if the person, Lynn's just mentioned that the person was offered interim at the beginning, but they couldn't access it, so that wasn't suitable accommodation, arguably. So they should challenge the failure to provide suitable accommodation. And I think I will have to wrap up now, but I'm just going to leave with a comment from Tiff saying, I wish I could tell you the nature of the horrific, traumatic, unlawful actions being done. I don't think you'd allow me to. Well, I will, but not tonight, I'm afraid, because I'm going to stop. But if you wanted to put a comment, I mean, I don't know. I mean, seriously, if you, it's a serious issue. But I mean, if you wanted to be able to talk about those things, we'd be interested to hear them, I'm sure, and learn from what you've been through. So if you can find my email address and send me a message, or do try and express them. I wouldn't expect you to write it all out in the comment section on here. And Adam has pointed out, oh dear, I hope this isn't affecting. Has anybody else noticed the audio echoing? I'll probably get a resounding yes from everybody, and then I realise I've set something up wrong. But I guess it hasn't prevented us from having what I think is a really interesting session tonight, and I hope anyone listening outside hasn't suffered too much from the echo. So we should be back on Thursday, all of us. Yeah. And then next week I should be okay. I promise I'm gonna do some technical stuff and get names and things and do the graphics better. That's good. It's fine now. So thank you everybody for taking part, and I'll look forward to seeing you again on Thursday. Oh no, it says only Mike's echoing. So can I just check? Do other people find Mike's echoing, or?
I think it's just when it goes to the system, so Karis and Shannon probably can't hear it.
All right, I'll have to work on that as well. So hopefully we'll get some sort the audio. I know it's a real pain because apparently audio is one of the first things that puts people off watching a video, surprisingly. Oh, hang on, we got one last. I'd like to ask questions about the right to buy. Is it being removed for all tenants or just for the new tenants? Thank you. I don't know, actually. Is it anyone heard right to buy being abolished?
There was a deadline. I don't know for sure. There's a deadline, maybe like a couple of weeks back or something. There was something to do with it, but I don't know what the detail was.
Oh, well, we'll have to look into that. But if I hear anything, I think it's still going on, although you wonder one day they'll put two and two together and realise that the shortage of housing may be better if they stop selling the stuff off. But then who am I to question policy over 40 years? So thanks, everybody. Good night, and see you on Thursday. Bye.